want to bring in now my guest for the afternoon, Judge Brandon Birmingham, as well as Bob Schock, a criminal defense attorney, and we have a judge out of Texas. First to you, Judge, what do you make of this testimony, specifically the fact you have this friend, Jordan Clark, who says he didn't even know that there was a baby in the house and he was over there?
It's pretty hurtful for the defense. A lot of the testimony that we're hearing today and that we've watched here on the network today is the actions of the defendant that are peculiar. In other words, jurors are always measuring the actions, in my mind, of the witnesses by what they would do. They would not laugh if they were being interviewed by the medical examiner with the death of their son. They would not hide a baby or not mention the fact that there was a baby. They would not be using methamphetamines when there was a baby around. So all of these things are going a long way to hurt the defense's case.
But does it help in any way, Judge, the fact that, you have her mentioning the drug use and then you have Jordan mentioning the drug use that all came around the same time frame that this child was found dead, in terms of where the defense is trying to go with their strategy?
Yeah, it is their strategy. The problem is, though, that it's a kind of a tricky strategy. In other words, to use the defense of intoxication, you're saying that you were intoxicated at the time. Nobody is going to like that the defense that she was high on methamphetamines as an excuse for conduct. I don't think jurors really appreciate that. So, yeah, you've got to set the defense up, and that's what they're doing. The background of their life at the time was involved with methamphetamines, so that's why they're putting it up there. And it's going to go right to that intoxication as a defense jury charge the jurors are going to get at the end of this case.
Bob Schock, criminal defense attorney, also with us via Skype. Do you think in the long run this intoxication defense could actually end up hurting Cheyanne Harris's case?
Yeah, as the judge just pointed out, jurors don't like the excuse of, well, I was just feeding my crystal meth habit. Additionally to that is she can't even articulate when it started, how often she was doing it, who she was doing it with, that it was never in the apartment. Her own inconsistencies harm her defense. So, I mean, it would be better off, in my opinion, if the defense potentially started laying the groundwork for the boyfriend being the person that they would start laying blame on, so to speak, by saying he's the one who got me addicted to crystal meth and he was giving it to me and I began being derelict in my duties because of him and things of the like, which may garner again some of this young mother overwhelmed sympathy postpartum. You have your expert testify and you kind of frame it that way. But going with this, I'm an addict, when you can't even articulate, the basic fundamental points which would make you an addict, I think harms them tremendously. Okay,
when we return, we have to take a quick break, but in Cheyanne Harris's own words, you're going to hear the interrogation tape, and you're going to hear what she said happened to that little child. Stay with us here on Law&Crime. Welcome back, everybody, to the Law&Crime Trial Network. We're inside the case against Cheyanne Harris. She's facing murder charges for the death of her 4-month-old son, Sterling. I want to bring in my guest now, Judge Brandon Birmingham out of Texas and Bob Schock, a criminal defense attorney out of Long Island. Thank you so much. You both have been giving such interesting insight into this case. I want to talk briefly, if we can, about where the defense, and we talked about this before the break, but specifically this postpartum element to the defense's strategy. Do you think that potentially could be, Judge Birmingham, the strongest part of the defense here?
I think it certainly is a defense that jurors can relate to. I think most of the jurors are going to have a hard time relating to an intoxication defense when we're talking about methamphetamines, but certainly the trauma of childbirth and all of the stress and everything that goes along with that, a young mother, things like that, is something that jurors can relate to. The state is always going to then focus back the jury on the facts of the case, the fact that, there was another child that was taken care of, that was okay, all of the conduct, the misleading, the covering up, the peculiar behavior once they came into contact with either law enforcement or CPS, things like that.
But the fact, Bob, and I think we discussed this a bit earlier, the fact that one child was perfectly fine and was taken care of, and there's the child there, the police interview with the father, Zachary Cohen, maybe that actually helps the defense, because how could they take care of one child so well, and what was the disconnect with the other child?
Exactly. I think it's all going to boil down to how well the defense expert is going to testify, because they're going to have either a psychologist, psychiatrist, social worker testify about postpartum depression, the effects that it could have on you, the effects that you could take care of the older child because it's in your normal course of what you've been dealing with for the last couple of years, and then adding this new element of a newborn on top of the fact that you might exacerbate the effects of postpartum depression with the intoxication. As you indicated when you asked the judge the question, do we think that this postpartum would be the better of the defenses, or the ones that the defense focuses more on? I think if you kind of link them together with the postpartum added on the top of this bad influence of the boyfriend with the drugs, you might begin to sway a juror or two. As I said earlier, I don't think you're getting an acquittal. No. Best thing for you is you might get a lesser included or a hung jury and try this thing again and maybe work out some sort of resolution with a plea after the fact if they can't get a conviction on the top count.
Yeah, I'm very curious to see where the defense is going to go in the quality of the experts that they bring to testify. I mean, in order to put this defense in, they have to, as part of their case, bring forward some kind of expert to say that this is what she suffered from, and that this could have caused her to do what she did. Otherwise, why even bother mentioning it? Okay, so we have to take a quick break here on the Law and Crime Network. I can also tell you the Iowa courtroom is on a break, but when it returns, we'll take you live there. In the meantime, stay with us here on Law and Crime. All right, so there you hear from Cheyanne Harris herself talking about taking care of her other daughter and then realizing that she hadn't, quote, heard from her son. Heard from her son. I mean, this child's 4 months old. It's not like, the child would say, Mommy, Mommy. Regardless, she says she hasn't heard from her son. And that's when she goes over and checks on the child and realizes the child's no longer alive. It took us a little while to get there because there was a lot of pauses in the police interrogation tape. But I want to bring on my guests, Judge Brandon Birmingham, Bob Schock, criminal defense attorney. Let's take it first to you, Judge. What do you make of just listening to how she talked about what happened?
You have to be listening to that and considering all of the things that the jurors know at that point. As you mentioned before, the smell almost knocked over some of the people, the investigators and the medical personnel that went in there. The statements that she's making right now, when considered in context of the state of that crime scene, are wholly inconsistent and very chilling, honestly.
Yeah, they are chilling, because remember that this police interview, Bob Schock, was the day that the boy was discovered by police, the day she discovered her child. And I know we can't make assumptions, but she seems to have little emotion when she's discussing this.
Yeah, very little emotion, but again, the defense will try to say that it's a state of shock. She can't believe it. They'll be able to play that aspect off. You just have to, for the defense expert, the benefit that the expert has is that this conversation was recorded. And the reason I say that is if the defense is going to make any headway with this postpartum argument, at a minimum, they have certain questions and answers on tape that they're going to be able to pull out of this conversation that they're going to tailor towards their argument, which shows them medically how she was being affected postpartum, et cetera. So I think the benefit for the defense is that you have the ability to have your expert not have to comb through a written conversation where oftentimes law enforcement leaves stuff out. Now you know in her own words what she's saying, and you might be able to bring things to light that, you know, the common person on the jury or even attorneys wouldn't think were indicative of postpartum. So that's one thing, you know, we've been talking about it for over an hour now, where one benefit for the defense they might be able to make some headway with. But again, yes, you're right. There's going to be jurors who are like, I would be in tears, crying my eyes out, and this girl has no affect, no emotion whatsoever as she's answering these questions.
Yeah, and I pointed this out earlier, but Judge, what did you make of that comment that she said to the police investigator that I realized I hadn't heard from my son in a while?
Well, I had the same reaction I think that you did. Is you might say that for a teenager that's in their room or something, but you're talking about a 4-month-old baby. And, you know, the other thing that struck me as I was listening to the audio of that is that this is somebody who seems to me to be searching her way through, thinking her way through what she's saying in a very deliberate kind of a way that has the ring of untruth to it. You know, oh, I made breakfast and I was doing this and I thought I hadn't checked on, and all of a sudden now, you know, I find this, you know, my son's is dead. And it just has the ring of untruth to it to me.
Yeah, and then remember, we also know that she told different people different stories about what had happened, how she had checked in on him the night before, how maybe he had died of SIDS. So a lot of this isn't lining up, especially her reaction the day that her son dies. You know, you're not hearing her screaming. You're hearing her really saying this in what seems to be a very calm, cool, and collected manner. And I think the jurors will find it quite troubling. Okay, I have to say goodbye to my great guests who have been with me this afternoon. Judge Birmingham, thank you so much. I know you have to go back to the bench. And Bob, I appreciate your time as well. I know you have a lot of work with your clients you got to get done, but we appreciate your commentary. We have to take a quick break here on the Law and Crime Network, but we'll be back. I believe trial will be starting up any minute now, so we'll take you live when we can. Stay with us.